Hello, Monique. Nice to see you. Unmute microphone, please. Okay.
Sorry. Yes, thank you. Hi, how are you doing?
Okay. We have 12 p.m. Sorry, so we can start the first session, Democracy and Political Rights under Lockdown. And I would like to ask Professor Roman Becker from Nikolaus Copernicus University in Toruń, Poznań, for chairing this session. Professor Roman Becker is a former president of the Political Science Association, Polish Political Science Association, as well. He was also a member of the IPSA board. I know that the list of panelists in this session, this is idea of Professor Becker. So welcome everybody, and maybe I would like to introduce Monica Falcao, who will be a discussant in this panel. Hello, Monica, once again. Nice to see you. Thank you very much for joining the session and for declaring this duty for you. I'm sorry. Once again, however, thank you very much. So, Roman, can you hear us? Can you see us? Okay, we are waiting for chair of this panel. Okay, Professor Becker will be very, very soon, so we are waiting. I'm sorry. Yes, bingo. Thank you very much, Roman, for joining this session. Once again, welcome on this session. And I would like to ask you to lead this session, okay? So the floor is open.
Thank you very much for organizers and for participation at the panel. I am honored to be a chair. So excellent panel titled Democracy and Political Rights under Lockdown. First speakers are Timea Drinocci and Emilio Meyer from Federal University of Minas Gerais in Brazil. transitioning from the COVID-19 pandemic, political and legal accountability for times of emergency. Can I kindly ask about start? Each panelist have 15 minutes. Thank you very much.
Good afternoon or good morning. Thank you so much for inviting us to the conference, and we are very happy to be here with you. And so we have a short presentation about the topic, and my colleague Emilio will start, and then I will jump in, and then he will finish it. And we have slides, so I guess that Emilio, you can start like sharing the screen, and we can start, right?
Okay, thank you so much for having us. Just put it in a way. Okay, so everyone can see it. Right, so hello to everyone. I'll just start without further delay. So our proposal was entitled Transition from COVID-19 Pandemic, Political and Legal Accountability for Times of Emergency. Both me and Timea have been working on the possibility of comparing two very different cases, which are the cases of Brazil and Hungary. So we are assuming here that the principle of the most different cases that is a kind of methodology that is used, for instance, for authors such as Ron Herschel, would be applicable actually in this case. And then we are trying to understand what are the differences on the approach to COVID-19 of countries that faced recently problems with the, let's say, quality of their democracy. So first of all, we are assuming that COVID-19 is a constitutional matter for both countries. And this is justified because of the way by which we demand a legislative, executive, and judicial branch to act both with politics and rulings concerning the pandemic. And then we can see that in those two cases, it is very clear how they dealt with several of these matters, demanding that those branches should act. It is a problem related to the right to health, as it appears in both constitutions, but it is something that it must be evaluated not only from the juridical perspective, but assuming that there are several other political, social, and economic implications involving this nominated as a constitutional matter. The problem with both countries also is the problem that we have in the case of Brazil, what happened as some authors describe as a kind of executive underreach. I will try to show that this is not properly the best description. And in the case of Hungary, a discussion at least if there was, let's say, abusive of executive measures in the case of dealing with COVID-19. Then we are trying to build the hypothesis that maybe transitional justice would be something important for dealing with the transition, let's say, from the pandemic momentum to the situation in which maybe we'll have some kind of, let's say, normalcy. This involves discussing political and legal accountability, the way by which transitology moved for transitional justice, and the way by which transitional justice recently have been tackling problems of social economic rights. So this kind of literature could be important to justify how the right to health being affected by COVID-19 pandemic can be evaluated with transitional matters. As I said right at the start, we are dealing with very different cases, the case of Hungary and the case of Brazil. So this would demand that we treat those cases as different cases. COVID-19, rule of law, and democracy are subjects that have been involved from very different perspectives. We can see that during the pandemic, the quality of democracy was not improved. Actually, it was the contrary. And what we see from the databases such as IDEA, VDEM, or the Economist Intelligence Unit is that the cases of Brazil and Hungary are special cases for the loss of democracy quality during the pandemic. I'll try to briefly report the case of Brazil for most of you who do not know it, except for our colleague Monique. The current discussion, and a discussion that demands what we can call transitional justice here, is the fact that we have a report from our National Congress that tries to show that President Bolsonaro committed crimes against humanity during the pandemic. So we can see that there are problems. We have a basis, a legal basis, sure, for the politics of COVID-19. There was a financial aid that was given by the government, but with a need that the National Congress should change it. And this report shows that there was a kind of deliberate intent from the government to expose the population to the virus. So the idea is that instead of executive underreach or politics that constitutional politics that were not accomplished by the government, what happened is that the government had a different approach to COVID-19, and it tried to show that if people got contagious by the disease, they would be protected because of this kind of contagious without actually scientific basis. And then what the report shows is that the corruption cases also took place during this fight against the pandemic. And all of these huge scenario would show that we could discuss political and legal accountability from the perspective of transitional justice. We have some backlash from our federal Supreme Court. Bolsonaro still has some kind of support in Brazil, something like 20%, but institutions, both the National Congress and the Federal Supreme Court, try to respond to the way by which he was conducting the pandemic. So subjects such as the power of states, or the way by which should people be vaccinated without forcefully happening this, but with a legal obligation to be vaccinated, were some of the subjects that the Federal Supreme Court debated. Please, Timmy, we will continue discussing the case of Hungary, and then I'll go back to just make the conclusions.
Yes, thank you. And now I think that you should stop sharing your screen, yeah, so that I can, 1 minute. Yeah. Okay, so I'm sharing, right?
Yes.
So yeah, so what we, as Emilio said, try to do is to compare things which might not be comparable, but we think that they are still comparable. So I'm trying to give you a little overview about the same thing which Emilio was talking about, legislative, executive, and judicial approach to the pandemic in Hungary. And I think that you know it as well, so I just will be very quick and brief in my summary. So you see, and you know that we had issues with this Authorization Act from 2020, when was it? Last year, yes, and And then also there was a kind of abuse with the introduction of the new statutory emergency. When the first constitutional emergency was terminated, they introduced a new one, and then they reintroduced the constitutional emergency. Not necessarily, actually, we don't know, but we could argue that they introduced the second one and they upheld it because of pandemic reasons. But there are other arguments which hold that maybe it was or everything has been done with the intention of deepening this autocratization process, which we are having in Hungary for years now. And on the other hand, as you know, because Fidesz has 2/3 majority in the parliament, it is like questionable whether they actually wanted to get more power, because they already has a lot of power. But yeah, so this is something which we should research a little bit more. And the other thing is about the overreach and underreach. This is again, your opinion about that might be like influenced by the fact how much you like the government or how much you dislike the government. We could say that if we use these words like overreach and underreach, that maybe in the beginning, because of those claims that the power was like grabbed even more, it could be said that it is a kind of overreach. On the other hand, personally, I believe that whatever was done in the first wave of the pandemic, it was necessary in Hungary, like lockdowns and all those measures which were introduced, like social distancing and others. On the other hand, right now, what you see in Hungary is that they are not doing anything in this fourth wave, and they are claiming that the vaccination is enough and there are no discussion about lockdown or introducing measures which been introduced in other neighboring states, for instance. And the argument here is that they don't want to introduce anything which is unpopular because we are having the election. We don't have any information, and we don't have enough information about the pandemic. Data are not released, and they need to go to the court to actually sue the public authorities to release otherwise publicly accessible data. And this lack of information, according to some, so this lack of information influences our will of Hungarians to get vaccinated. And if we assume that it is important to get vaccinated, then it is concerning that because of the lack of information, people just don't want to get the first dose. If you get the first dose or the second one, you go and you get the other one. But now it seems to be very difficult to get people to get even the first dose. I think that we have around like 60-something% of the people vaccinated. And what else? We had these corruption issues, or how and when, and they bought the respirators and what type of vaccines they bought and why, and whether they are like actually effective or not. And then it goes back to the lack of information. Basically because of the situation and because we don't have data, it is very difficult for us to actually have a clear picture about what's going on in the healthcare system. But what we know is that to a certain extent, it became like inaccessible in a sense that there are long waiting lists. We always had long waiting lists, but it's like getting even longer. And so that is it basically. And yes, the reform in the pandemic, in the beginning of the pandemic, the government decided to reform the healthcare system, and they reformed the legal relationship of doctors, and it made some of them to leave the healthcare system. So now we have increasing number of patients and the long waiting lists, and then doctors just left their profession or the public sphere, which does not help obviously the fight against the pandemic, and which obviously affects our right to healthcare. And as for judicial rulings, you know that our constitutional court is packed, and they don't really help to help us, the people, to access to our constitutional rights. And they always, in the cases which appeared before them, they always like support the government. And when they had opportunity to talk something about the emergency situation, what it means from a constitutional law perspective, they did not necessarily live with it. So what they do is just issuing some decisions, and when you read them, you just, wow, really, this is the standard, and unfortunately, that is the standard. But what is important here is that they are not, obviously, they are not counterbalancing either the over or the underreach of the government, if you can say that. And I think that now I will give back the word to Emilio.
Thank you very much.
Just to try to, okay. Just to try to wrap it up. So I think that we think that the most important things that we should try to compare here is to show that, first of all, the organization of the state, the case of Brazil, a federal state, and the case of Hungary, a central state, is important on evaluating the politics. So in the case of Brazil, this was extremely important to counterbalance what the federal government was trying to do with the pandemic. So most of the governors have very different approaches to the pandemic that comparable to that one that was exercised by the federal government. And then the federal Supreme Court needed to decide on these issues, giving reason for the state governors. It is also important to compare the way by which the presidential system works in Brazil. So Bolsonaro was also controlled by the fragmentary way by which political parties are organized in Brazil. If you compare this to the case of Hungary, in which the majority supported by FIS was important to conduct Orbán's policies. There is also a difference on the civil-military relationships. In the case of Brazil, the presence of the military on the federal government were truly important to give support to Bolsonaro for his most, let's say, non-scientific based politics. And in the case of Hungary, it is not a problem of influence of the military on civilian government. And finally, what we can see is that probably the result of those measures will be decided mostly by political instead of legal accountability. If Bolsonaro, in the case of Brazil, is not re-elected, of course, legal accountability is something that is more present in the horizon. But being he elected, things can get worse if we can talk about transitional measures for responding to the pandemic. And then that's it. Thank you so much. We hope we can clarify some of the things that we explained here in the discussion.
Thank you very much. Can I introduce Professor Monique Falcão from Portugal? She is our discutant. Have you any comments or questions?
Yes, actually, it was really interesting to see that that we have some, I would say, anti-democratic facts and problems going in both countries, unfortunately, but they exist. So I will not take so long time, but I'd like to ask only if you see, or how can you see the judiciary role in this game, I would say like this, in this dialogue between, like you said, crime or illiberal politics from Hungary, and in Brazil also we have also, I would say, quite the same discussions. And in Brazil, I guess that's a little, only a different point, I would say, or also very interesting is that we have the the discussion and between the relationship of public health, like a collective interest on one side, and the other side, the individual liberties or the individual freedom. Actually, as we have a pandemic, for me, it's quite clear that the public health, of course, it's over all individual liberties. But it seems that in Brazil, we have still this discussion, which seems to me to be quite primary discussion, like it's under than basic, but okay. So I'd like to ask if you have some comments about the role of the judiciary field, most about the constitutional court that has a big role in Brazil as I would say, between it's trying to get in the dialogue between civil society and executive power, and of course has a political role in this case. But in Hungary, if you have some comments about actually this one. Yes, the whole of from judiciary power is this. Thank you very much.
Yes, please.
Yeah, can I just make a short comment? Thank you, Monique, for your questions. I think that what has been happening in Brazil from 2019 on is that the Federal Supreme Court tried to act as I just said, a form of counterbalance Bolsonaro's politics, both in the case of pandemic and beyond it. So the court tried in a certain sense to recover the way by which it was worried with fundamental rights and political liberties, but not in the sense that individual liberties, as you mentioned, were managed by the supporters of Bolsonaro. So most of them, and including the Minister of Health, was just mentioning that we're talking about opposing the right to health or the right to life, to individual liberty. So this is a very, as you said, primary discussion, and it is used in a primary sense just to afford new support from people who do not theorize too much about a conflict between those rights. So, and I think that the Federal Supreme Court stood with the idea that health is a public issue, even in the way the 1988 Constitution provides for it. So then I think that the Federal Supreme Court has a very important role in this sense. So if we take a look in the years from 2014 to 2018, the Federal Supreme Court has a very, let's say, disturbing role in politics and deciding cases that it should not properly decide, or even not deciding cases that it should decide. So, and then from 2019 on, I think that the court was conscious that it should debate the way by which public health have been dealt by the federal government, and I think in a proper sense. So if anyone wants to read about it, the Federal Supreme Court has published a volume with all of its most important rulings concerning COVID-19. And I think that this is an interesting and important chapter of the court's history. I don't know if Timea wants to say something.
Yes, thank you so much, Monique. Your question just highlights the big difference between Brazil and Hungary. Our court is packed, so they do whatever the government wants to have. I mean, wants to introduce. They don't say that it's bad, that it's unconstitutional. They maintain all the constitutionality of all the measures. I give you two examples. The first, I mean, there is one example for that. There was this issue that you cannot exercise your right to assembly during the pandemic. So now, 1 year ago, when there was a gathering organized by people who participated in this gathering with their car, and they did not leave the car. So it was the gathering of cars, and so social distancing was maintained because you did not, I mean, they did not get out of the car. And then it was considered to be illegal. So they were like, okay, now our right to assembly was violated by the state, wasn't it? And then they went to the Constitutional Court, and the Constitutional Court said that no, nothing is wrong with that because it is up to the government to decide how to protect public health and how to deal with the pandemic. So now everything is fine with this measure, which is obviously unnecessary and unproportionate, right? And there is another thing. What you can expect from this kind of Constitutional Court, just recall the slide I showed you with how they decide, right? So there is this new law about, and this is about public health and individual liberty, whether you need, you have to go and vaccinate, whether it is obligatory or not. And now the government introduced, I mean, it is not the government, the parliament, I mean, but it doesn't matter. I could even say that the prime minister. So the government introduced that it is obligatory to get vaccinated if you are employed in a public sphere in a narrow sense. So everybody who is employed in a public authority in a narrow sense, they need to get vaccinated. Otherwise, they will be sent to an unpaid holiday and so on and so forth. But then, as for the private sphere, what the government did, they put the responsibility to protect public health, which is a state obligation, isn't it, to the employers in the private sphere. And obviously there is why are you doing that? I mean, we have to take them, I mean, do we have to make them like responsible for that and accountable for that? Most probably the Constitutional Court will not make this step because they would say that it is like that it is the best option possible. Maybe they will say that okay, there is a constitutional requirement, but then they would not change this approach. But then it is still at least a political question or political responsibility, a question of political responsibility, whether you as people, the voters, whether you allow your government to do that, not to take responsible measures. And why they are not taking this responsible, I mean, obviously everything is relative. It would be responsible for me that they would like say something like serious, hey, you have to do this and that because we have a pandemic. So if you take this approach, then I think that at least from a political perspective, we need to take them responsible in the next election, but who knows what happened in the next election and whether it would, the pandemic and how they deal with the pandemic would actually influence the will of the people to vote for or against them. But we will see it in next spring. So thank you.
Thank you very much. I would like to invite next panelist. Max Steuer is ready. Max is from Indian Hindal Global University and from Comenius University in Bratislava. He will be speak about life or survival. What comes first? Fundamental rights and Slovak parliamentary debates on emergency legislation. Can I please, Max?
Thank you very much. Greetings to everyone and hope you can hear me well. It's my pleasure to be part of this conference and in particular to speak after Professor Adam Bodnar and Professor Stime Advinozzi and Emilio Meyer, and all these insights have been very enriching, and I think they speak to the small case study that I would like to address in today's session from my end, and that is the case study of Slovakia. But even within that, I would be focusing specifically on the parliamentary debates on emergency legislation and on how justifications for restrictions on rights, I would say more than political rights, fundamental rights in general, have been invoked in the Slovak parliamentary debates, and what can that tell us also about the state of Slovak democracy and the position of Slovakia towards fundamental rights. And we know that Slovakia is a country that, unlike Hungary and Poland, is not yet listed in these democracy indices that were also mentioned, or various reports as showing a deterioration of democracy, but has the pandemic affected this process in a certain way? That would be also a debate, a broader debate, to which this case study would like to offer a small perspective. Now, in the title, you might observe this strangely sounding dichotomy of life versus survival, which also may seem to be synonyms, but in fact, I'm following in this discussion perspectives that do try to, well, at least in some way, differentiate between the two and highlight the importance of political life in addition to biological survival, particularly in the context of fundamental rights protection and in the context of emergencies, which, as was already mentioned in other contexts, have been declared in many jurisdictions in relationship to the pandemic. So let me try to guide you very briefly through the theoretical framework that basis or provides the sort of foundation for the empirical study of the justifications on emergency legislation in Slovak parliamentary debates. So, as some of you might be familiar with, this distinction between life versus survival, although it is much older, has been articulated, I think, quite promptly and effectively by George Agamben, philosopher, who highlights that in the situations of emergencies, what we tend to observe is that even though the measures that are being implemented are still being implemented under the guise of law, they are implemented in ways that legal principles get sidelined. So he has this strangely looking phrase of the force of law becoming basically force only because law gets crossed out from the equation. And this, of course, is a very relevant framework, I think, for discussing and studying the emergency legislation invoked in the context of the COVID pandemic. In addition to Agamben, I'm trying to utilize perspectives from constitutional theory that also deal with states of emergency. In particular, Carl Schmitt, the infamous theorist who one has to say has been supportive of the Nazi regime, who also articulated a distinction between what he calls a commissarial and a sovereign dictatorship, whereby the commissarial dictatorship is one that temporarily attains emergency powers in order to then be able to bring back what normalcy is, whereas sovereign dictatorship would not be limited by this temporariness. But of course, the big problem here is the question of who decides. That is also a Schmittian question. Which are the institutions that matter? And the institutions have been already discussed in the previous contributions: courts, executives, the public, the media as well. And in this context, I would like to highlight also the importance again of justifications, right? So in order to be able to understand what kinds of regime frameworks are we entering in the context of emergency legislation being adopted due to the COVID pandemic, it is useful to look into the justifications, how political actors who enact these measures claim these measures to be necessary, to be normal, to be needed, to be important, perhaps even legitimate. Now, Schmitt's distinction between constitutional and sovereign dictatorship, and I don't have time to go into this in detail, we can come back to it in the discussion, can also be questioned from the perspective of creating a very limited framework whereby even the commissarial dictatorship will transform into a sovereign dictatorship or will not be able to uphold some constraints on executive power. And this is where another theorist, historian, political scholar, Clinton Rossiter, comes in, who uses the idea of constitutional dictatorship, where there is one more step as compared to commissarial dictatorship, at least in my reading, and that is that the executive acknowledges that by attaining emergency powers, it is doing something that it should not normally do. It is exceeding the scope of its operations in the regime, and it justifies this and communicates this, including through the media, media in an open manner. This is not present. This element, this feature is not present in the commissarial dictatorship. Now, in order to move to the empirical study, I just wanted to have a brief note on the Slovak case in terms of the empirical developments. Unfortunately, similarly to many other Central European countries, there is a large surge of COVID-19 cases at the moment. But in the early stages of the pandemic, in the spring of 2020, in fact, these countries, and in particular Slovakia, maybe less so some other countries in the region, have been praised for being able to contain the virus. But if we look into the legal procedures through which these containments have been achieved, as well as the human rights implications of these procedures, we can see that at the very least, we observe what I called in a short contribution to be state panic, to be the state not really knowing what to do and excessively restricting many fundamental rights in the process. But going further, and also ex post facto, the reports that were generated indicate that it might be a state prejudice. For example, when Roma settlements were cordoned off by the authorities in the early stages of the pandemic with some kind of an idea to contain the virus so that if it affects the Roma population, then it doesn't get somehow out and affects the rest of the population. So this is clearly based on prejudicial views that have been also confirmed by several NGOs and monitoring organizations. What I'm, however, looking at empirically in this study in particular is that of the parliamentary debates and their justifications of selected rights restrictions adopted via the parliamentary procedures in the context of the state of emergency. Now, I'm particularly focusing on the right to privacy because there have been some important debates related to right to privacy and its restrictions in the Slovak parliament, as well as on a broader extension of the reasons to declare a state of emergency and of the competences of the executive to prolong the state of emergency that was also debated in December 2020 in the parliament. But an argument could well be made that more of these debates should be included into the analysis. I will not discuss in detail the methodology, the type of parliamentary discourse analysis that I employ, but the purpose is specified here as well, identifying the degree of sensitivity or lack thereof of the MPs vis-a-vis fundamental rights restrictions. So going back to Rossiter, going back to constitutional dictatorship, right, that we are aware, the actors who are presenting their justifications are aware that they are doing something or they are endorsing something in case of the parliamentarians that they shouldn't normally endorse. Now, here I just provide a very brief glimpse on the number of contributions in these parliamentary debates that have taken place, 201 contributions in total. Some of them longer speeches, most of them short interventions according to the rules of procedure that we have in the Slovak Parliament. 5 debates have been looked at. Some of them pertain to related issues of privacy and surveillance measures. In particular, the last debate in December 2020 is the one that deliberated on the amendment to the Constitutional Act on State Security, the justification for the executive to prolong the state of emergency indefinitely with parliamentary consent and possible constitutional court review. Now, the only point from this table that I want to communicate to you pertains to the party distribution. And of course, I do not have time to introduce the Slovak party system here. One information that may be useful for the context is that Slovakia currently has a constitutional majority, a coalition government with a constitutional majority, so also with possible greater risks of abuse. But when it comes to these particular debates and the actors who have spoken, who presented their opinions in these debates, it's almost exclusively the opposition. Now, that may be something that is quite frequent when we study parliamentary debates, but the problem that emerges in Slovakia in this context is that the opposition is almost entirely comprised of either the extreme right or various nationalists and also actors with arguably anti-democratic leanings. So in a sense, if the opposition dominates in the debates, it means that extreme right or actors with at least very questionable democratic credentials dominate in the debate. So very briefly, 3 tentative results. There is still more work needed to be invested into this analysis. But the first issue that we can observe is that the fundamental rights, and this stems also to some extent from the table I just showed you on the party distribution, that the fundamental rights justifications, right, so claims that are associated with references to fundamental rights have been appropriated by these nationalist actors and the extreme right. So almost all of the references to fundamental rights have come from these actors arguing against some restrictions or against some coalition proposals, referring to fundamental rights in their justifications. So I tentatively call it the weaponization of human rights language, because of course, if we look into the profiles of these actors, we see that they would be the first who would be very glad to implement a lot of restrictions that would also favor their position in case they were in power. The second issue that we may observe is the readiness, and this speaks very much to Professor Bodnar's reference to the digital age and the role of digital technology in shaping the COVID pandemic and its implications for democracy. The readiness to embrace technological solutions, advancing surveillance, even at the cost of handing over more control to private companies. Now, I don't have time again to discuss in detail the legislation that relates to this in Slovakia and the Constitutional Court response to this legislation. But one illustration is provided by a moment in the pandemic where the Slovak government has introduced a mandatory location tracing app for those Slovak citizens returning from abroad to their homes, because of this idea of distrust that these citizens, if they are not monitored by this application, then they will not uphold, they will not stick to the quarantine requirements. However, the app was not approved in time by the private companies, I think Apple and Google, and as a result, basically Slovak citizens were left stranded on the borders trying to download this app, which however wasn't approved by the private companies, and at the same time not being able to enter the country because the downloading of the app, which of course has privacy interferences, was a condition for entering the country, right? So in this case, I think it's very illustrative to see how the private companies are gaining control and how the executive in this case willingly gave over control to the private companies, hoping that, well, Apple and Google will approve the app in time. Now, the third issue that I would like to highlight, with my time also running out, are democratic actors, right? So I said that mostly in these debates, it was extreme right or nationalist actors with questionable leanings towards democracy who have appeared to have spoken. However, there are also interventions from the coalition or from actors whom we could consider to be democratic. Now, they, however, are embracing a rhetoric of public safety or security in contradiction to human rights, as if these goals were really not compatible with each other. If we want public safety or security, we need to go against human rights. We cannot have both at the same time. And to me, this speaks back to the Agambenian distinction between survival and life, the idea that we need to prioritize biological survival over political life. We cannot have both. And this, is certainly not a call for removing all kinds of restrictions or for not for the executive not really taking steps. Many steps are certainly needed. However, it does raise the issue of lack of justifications. And in Slovakia, and that is my concluding point, the parliamentary activities have not been suspended, so the parliament can be seen as playing a relevant role, at least formally, in the processes. However, if we look into the debates and the justifications, we see that it has been unable, by and large, to present some human rights justifications, to present also ways to scrutinize, to hold accountable the executive, but also to just be able to introduce more of the human rights language into the discussion. And worryingly, what we observe is that the human rights language has actually been invoked by extreme right and nationalist actors. So this quote by Benjamin Franklin has actually been uttered in the Slovak parliament in one of these debates, but it has been uttered by an extreme right MP. Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. So remains to be seen whether democratic actors can recapture this human rights language through many of the channels, some of which were also or will be discussed at this conference. Thank you very much and looking forward to the discussion.
Thank you very much. I suppose Monique is very glad from the paper. Can I kindly ask Monique?
Yes, thank you very much, Roman. So actually, I'd like to ask, how do you see eventually this civil society reaction, partly pro, partly against all this movement from state powers, the government decisions, mostly considering, I would say, the misappropriation of human rights languages. Just like you said, there's a resignification, but in a bad way, I would say, about human rights. So how do you see, because you talked about Agamben. So when you talked about Agamben, I always remember his conception of civil disobedience. So in this case, how do you see it? I mean, and yeah, that's I would say the role of the civil society, mostly specifically in this case. I guess you talked already about it, but if you don't mind to only give us a little more, it would be great. Thank you.
Yes, thank you very much, Professor Monique. I think this is a very important question and possibly sort of beyond the scope of this paper to an extent, but certainly because we see that the parliament doesn't represent a counterweight to the executive's justifications, if there are any, of enhancing emergency measures. We need to turn to other actors. The judiciary could be one, and certainly the media and the civil society would be the other. Now in Slovakia, in the initial stages, at least, of the pandemic, and this is based more on subjective observations than some systematic data, but I do not see too much resistance from civil society actors towards these measures. Certainly there were some critiques. Perhaps they were coming more from constitutional lawyers than from some civil society organizations. There was a lot of critique vis-a-vis the cordoning off of the Roma settlements that I mentioned by civil society actors, but less so when it comes to the restrictions, for instance, state quarantine of those coming from abroad. So this might have had to do something with the fact that in those early stages of the pandemic, of course, it was uniquely an extraordinary situation. No one knew what can be done. I don't want to go as far as to say that not just the state was in panic, but also some civil society actors were in panic, but certainly there hasn't been very effective response. However, afterwards, and moving more towards the contemporary situation, we can see a lot of civil society actors also looking back into those, for example, executive decrees that have been invoked in relation to the emergency powers of the Public Health Authority, which is essentially an executive agency. And in this context, these have been certainly questioned, and the civil society has played a very important role in also initiating judicial proceedings, initiating or at least participating in the debate with the Constitutional Court as well over the possible invalidation of some of these measures. Many proceedings are still ongoing. On the Agamben bit, I have to say I would need to study more his conception of civil disobedience, and I would be glad to hear more from you on that point as well. Thanks.
Thank you very much. Can I kindly ask Agnieszka Bieńkacała, professor from Nicolaus Copernicus University, Poland. I suppose she will speak about limiting political rights during COVID-19 pandemic in illiberal constitutionalism, the case of Poland. Please, Agnieszka.
Yes, thank you very much. Thank you.
15 minutes. 15 minutes.
Okay, thank you. Thank you very much for the invitation to this conference and giving me this opportunity to speak a little bit about Poland, illiberal constitutionalism, and limitation of political rights during COVID-19 pandemic. And yes, I am honored to be here and very happy to be here. As I last 2 weeks I was traveling around the world, and yes, it was a very stressful trip for me. And now I am really happy to be here safe and yes, to speak to you. So as for my talk, I would like to focus on political rights, obviously, pandemic and emergency, and illiberal constitutionalism. So as you probably know, Poland is among those states that can be named as illiberal constitutionalist states. What it means that democracy and rule of law and human rights protection are defective and deteriorate. And so what we can see in these components of from the one side, there are components, they are components of liberal constitutionalism, but what we can see within illiberal constitutionalism this deterioration or different understanding of those components. So as for a democracy, we can say that in Poland, but not only in Poland, also in Hungary, we have majoritarian version of democracy, and it is connected with some exclusion of some groups of people. I will talk about that a little bit later. We have elections that are free but not fair, and it was also the case during the first wave of COVID-19. We have defective legislative process, and media freedom is not fully provided. As for the rule of law, we can see that rule of law was transformed into illiberal legality, and it is especially connected with defective judicial independence and impartiality. So judiciary is less impartial and less independent, and what we can see that constitutional tribunal in Poland is totally not impartial, and cannot provide this constitutional justice, which is also important as for human rights. We can say that human rights, because of that, is or human rights are less protected. They are the level of protection is diminished, and this most worrying examples are connected with abortion decision of the Polish Constitutional Court, and the decision in which Constitutional Tribunal said that Article 6 of European Convention of Human Rights is not conform with the Polish Constitution. So these are mainly elements of liberal constitutionalism. For constraint of on public power, it is less and less provided because of the decision of Constitutional Tribunal, especially connected with the European Union law. Considering the illiberalization of human rights, we can see that certain groups of people are targeted by Polish rulers. And obviously it is connected with political opponents. And it was visible since the beginning of this illiberal transformation. Within the political communication, also some group of people were targeted. We can say this about LGBTQI plus community, women, and migrants. Before pandemic, it was only about communication, political communication. But when pandemic broke out, it was the situation, emergency situation, was used to implement some measures against those groups of people. So what we see first, we can see that it were women who were targeted, and it can be connected with the abortion decision last year. The Constitutional Tribunal provided almost total ban on abortion, and yes, in addition, we can say that there was a further attack on women's rights in this respect with the Citizens Initiative that provided total ban and penalization of abortion, and not only for those who perform this procedure, but also on women. Fortunately, it was not rejected by Parliament. As for LGBTQI people, we also have this citizens initiative, legislative initiative, that would provide a ban on assemblies that are connected with LGBTQI community. Yes, what in addition, I could say that we have the combination of three factors during pandemic, which is abuse of emergency situation. It was done twice, but obviously Poland is not the first one. We took this tendency, liberal tendency, after Hungarian government. Yes, the most targeted groups of people are, as I said, political opponents, LGBTQI plus community, migrants, and women. And the third element is connected with the political rights, because we can see that during emergencies, electoral rights were targeted, also freedom of assembly and media freedom that translates into freedom of information and the right to be informed. And these elements or freedoms are endangered. Starting from the beginning of pandemic, we can, I would like to say about the first emergency that is connected with COVID-19. So what Polish authorities did was they provided extra constitutional emergency because of the election that were planned to perform. And this extra constitutional emergency, state of epidemic, allowed to hold the election and at the same time suppress rights of political opponents of the government. Also, the ban on assemblies was introduced, and we could observe that it was abused several times to defeat protests. For example, protests of women against the Constitutional Tribunal decision. As for the second emergency, now it is connected with Afghan events and the crisis occurred. The Polish government first wrongly applied the constitutional rules and introduced a constitutional emergency that was not adequate to the threat. And the second thing is that now we have the extra constitutional emergency that is similar to the previous constitutional emergency. Who is targeted? Obviously, migrants. And yes, we can observe also the violation of the media freedom and our right to be informed. So we can say that it is a continuation of what was done during the first wave of pandemic, and obviously it is connected with another threat, and but it is the same pattern as it was previously. Yeah, and it is connected with the legality of measures taken. So we can briefly say that the measures are not conform with constitution, and yes, they treat human rights. In conclusion, I would like to say that what we see it is a normal perspective of illiberal constitutionalism. Those two emergencies were the emergency situations were abused by Polish authorities to limit political rights of certain group of peoples, Poles. Yeah, what is the reason why the illiberals abused constitutional rules? We can say that it is obviously, and it is said within academia, that it is about power. What I could say, and from my perspective, it is not about power, but rather about support. And it is not uncommon. It was done before, obviously, and we can identify the pattern of the psychological effect, and it was measured by a psychologist. And what they saw, it is for American elections, that Americans voted for taller presidents during war times. So now we can see also in Poland that this crisis situation, it is, yeah, by political rulers know that and try to get more support than power, because it is about legitimacy of the system, illiberal constitutionalism. So I can say that migration crisis in 2021 was not, that this behavior of illiberals is not accidental. Thank you very much.
Thank you very much. Monica, it's time for you.
Thank you, Roman. And actually, Agnieszka, it's really amazing because you have detailed the like we say, also the waves of increasing these anti-democratic acts. But I'd like to ask you if you would like to tell us a little more about when you said the judiciary was less impartial and less independent. I was quite curious to hear a little more about it, if you don't mind, to tell us some examples, or how do you see it, in which way it was. Thank you very much.
Yes, thank you very much. This is a very important question, and it is connected obviously with the crucial element of the liberal constitutionalism, but I think that it is especially important when we speak about Poland, because yes, in Poland it is the judiciary is the most targeted branch. So what we can identify. The problem is with the procedure of election of judges, because the procedure involves National Council for Judiciary, and we know that it was done 4 years ago. The changes were introduced, and now we have, instead of impartial body, we have a political one. And this is why Polish judiciary cannot be fully recognized or recognized as a fully independent, because the political branches are involved in the procedure of electing judges. As for Constitutional Tribunal, as you probably know, we have the body that is part by loyalists, and we have also this problem with additional judges that perform their duties. And we have two very important decisions of European Court of Human Rights indicating that Polish Constitutional Tribunal cannot be recognized as a tribunal properly chosen and established by law. And this is why Constitutional Tribunal targeted these decisions, like Xeroflor. This is what was in their mind. And yes, this is about that. Yes, that we have this political involvement within the performance of judicial decisions. Thank you.
Thank you very much. Can I kindly ask Mykola Polowy from Donetsk University, National University, on exile in Ukraine? Mykola will speak about the lockdown as a booster for authoritarian term from the perspective of model of political density. Please, Mykola.
Thank you very much. Are you hearing me? Are you see my presentation?
Yes, we see.
Yes, thank you. Thank you very much, Professor, for inviting for this conference. I very appreciate it. And the aim of my presentation is to assess an impact of quarantine measures and lockdowns related to the control of COVID-19 epidemic on the dynamics of authoritarian tendencies in modern states, on the example of Ukraine and Ukrainian realities. Shortly before the pandemic, I created a theoretical model of political density, which determines some kind of relationship between the degree of density of current political process and stability of the regime. But it turned out that the model establishes a certain correlation between the density of politics and degree of democracy and authoritarianism of the political regime also. And the main provisions of this model connect with the concepts of political volume, density of social relations, density of politics, proportion of political interactions and proportion of political actors, integrity of political actors, and individual common political responsibility. The density of social relations is the first concept, which depends on the number of interactions and the number of subjects of those interactions. We can see that I'll try to show maybe. we can see that density of social relations consists from number of all interactions and number of individual subjects of social relations. The next concept of my model is proportion of political interactions, which is relation of number of political interactions and number of all interactions in society. And the same kind of numbering of proportion of political actors, which is the relation of the number of subjects of political transactions and entire population of the country. I base it on the assumption that the density of social relations is connected with political interactions. I think that every political interactions include any interaction in which at least one party is a translator of political text, and then political text with attributes of subjectivity is directed toward politics. Thus, I draw on the Thomas theorem, according to which if situation recognized as real, it is real and its consequences. Applied to political subjectivity, this means, for example, that if I believe that I'm acting as in the sphere of politics, then I recognize myself as a subject, and my actions have the character of the subject's actions, or have the character of subjectivity in political sense. I mean that both physical actions and simple text are treated as the text, and I'm referring especially to the translator of political text, meaning that it is not necessary to know who is the author of the text. I mean only some kind of translation. Therefore, I define previous concepts, and the next and the main concept in our in this presentation is the density of politics, which is consists of proportion of political interactions and proportion of political actors, which is consists from relation of number of interaction and number of all interactions, and number of political subjects, of every political transactions, and entire population of the country. Generally speaking, I also assume that possibility to put concept of integrity of political actors and individual political responsibility. And in short resume, I have to say that the more number of political actors, individual subject, political translators per one volume of political life, the less political responsibility of the individual actor we can see. But I understand time restrictions that let's come to political atmosphere without responsibility and integrity. I assume the possibility of defining political atmosphere as a necessary environment for the existence of a state. And also I assume that it is possible to interpret a rarefied and, on the contrary, an extremely dense of political atmosphere as characteristics of the political regime in a given state. Actually, the original purpose of creating this model was to create a tool for predicting the onset of political crisis in one neighboring country for Ukraine. And it is assumed that at the moment of crisis, the action of the masses, in spirit in the sense of induced political subjectivity, are added to action of the ordinary elite, and lead to sharp increase of number of political transactions, transactions directed to the same object, the state of state policy, and those chain of events leads to a sharp increase of the density of politics. This sharp increase in the density of politics with a parallel increase in number of actors and increasing of their irresponsibility is the evidence, will be the evidence of the crisis. I can't say for sure of what is the cause and what is the consequence in this nexus, but I suggest that the dynamics of policy density can serve as an indicator of regimes' movement toward democracy or authoritarianism. Based on the model, I suggest that evidence of movement toward democracy would be an increase of in density of politics, and evidence of movement toward authoritarianism would be a thinning of political atmosphere, that is decrease of density of politics. And it seems for me that the contemporary situation, for example, in Russia, increasing and tightening of regime is the good example for such process. Thus, according to the model, I proposed ceteris paribus, an authoritarian regime is characterized by a lower density of politics, of political interactions, than a democratic one. But let's leave Russia and previous concepts, and let's go to the initial hypothesis of the applied part of my research. The initial hypothesis stated that with the onset of lockdown, democracy weakens and authoritarian tendencies intensify. Based on the model, I tried to verify this in general quite popular hypothesis for today on the materials of Ukraine. I take three main channels of political information in Ukraine: Ukrainian Pravda, or Ukrainian Truth, Джерело Тижня, and Union, and search for reference to every political transactions. Let me remind that in information era, every political transactions received an existence only in the form of some public communicative act, which is recorded in media messages. Data were taken from mid-2090 to the beginning of December 2021. The middle of 2090 had to be taken as a starting point because, unfortunately for this research, April-May 2090 were characterized by abnormally high rates of political interactions in connection with our presidential elections, and it was not possible to exclude this electoral part from the total number of political transactions. According to my model, political density is captured as a product of interactions at number of actors, and a decrease in any of the multipliers leads to a decrease in policy density. The results showed here. On the vertical axis is the share of political interactions on the total volume of interactions carried out in the information field, and the horizontal axis represents time. We see a steadily downward trend of political interactions over the past 2 years. Moreover, due to the specifics of the period of the epidemic, the agenda is also simplified. Up to 10% of all political interactions during this period are related to medical and health care activities. In other words, the number of shown in the graph should be reduced to another 10% lower. At the same time, the number of actors involved in political interactions decreased by 12% over 2 years, and the decrease was primarily in the non-governmental organizations sector, and it was due to the leaving the political scene of small and insufficiently institutionalized actors. Thus, according to the proposed model, the Found trends indicate a decrease in the density of politics in modern Ukraine. And the working hypothesis of the lockdown, that the lockdown is accompanied by a strengthening of authoritarian tendencies, is confirmed on the material of Ukraine. We can state that objectively and quite possibly, irrespective of the true wishes of the actors, authoritarian tendencies intensify in the process of the lockdown, which I denote by the term authoritarian turn. I don't believe with it that the introduction of COVID restriction is a necessary trigger for the strengthening of authoritarian tendencies, but I'm inclined to argue that any COVID restrictions, any lockdown restrictions are the booster for authoritarian political practices, and this is the last point of my presentation. Thank you. I tried to be very fast.
Thank you very much. I suppose Monique has a wonderful question or comment.
Oh, wonderful, I don't know, but for sure I can.
Deep intensity.
Yeah,
Please.
that's really interesting actually to see all these calculations, because it got really deep. All this, your methodology is really amazing. So as we see a kind of increasing, I would say like this, of how can I say, anti-democratic and also authoritarian way from the government because of this decreasing of political density. How do you see this can be managed in the following month or in the following years until it gets a new point of stability maybe? Do you think that we can have another stability in the following month or in the following years? Maybe when pandemic gets more stable or not? I mean, that's how do you see this for the future? Do you that's actually, I got quite curious because your diagnosis was very interesting to see the decreasing of the political density, but I'd like to ask if you see some increasing actually or not.
Thank you for the question. Maybe I haven't good news for you, but if in short, I think that COVID, you know, I heard previous speeches, and I understand that Ukraine isn't very different for other countries because, for example, in Ukraine we have very weak state which can to proclaim some restrictions, but haven't possibilities to improve those restrictions and to strengthen these restrictions because nobody take it seriously, for example, in Ukrainian society. That's why I think that Ukrainian may be some kind different of other European countries, but on the material of Ukraine, I don't see any possibility to, in the further 2 or 3 years, to change in this trend. I think that maybe there are other more deepened causes for this lowering trend, which were only really boosted by trying of COVID restrictions. But I think that the main good point is that we can monitor such dynamic, and if or when it will go back to more democratic practices, we could see it this model. It is my point of view.
Thank you very much. Can I kindly ask Joanna Merak from Adam Mickiewicz University. Joanna will be speak about social consent to implement anti-democratic solutions. It will be about Baltic states, democracies under lockdown. Can I kindly, please? Yes.
Okay. Thank you so much for your kind introduction. I will present today the introduction to empirical research. The idea for this introduction emerged out of our discussion over the conclusions that we formulated in our book. Working with Roman, Maciej, Timea, Max, Agnieszka, and it was a great pleasure to work with you, and working on neo-militant and quasi-militant democracies showed us that we have to distinguish between two phases of the trajectories of neo-militant democracies continuance. And we have to distinguish because we have a crisis-driven phase and the pandemic-driven phase. And today I'd like to focus on the pandemic-driven phase. So I will pay attention to social consent to implement anti-democratic solutions in Baltic states democracies under lockdown. And I will begin with preliminary assumptions that say that by limiting the participation of political nations in making political decisions in Europe during the pandemic, the ruling elites increased the scope of their own power competences. Nevertheless, in the Baltic states, self-defense mechanisms have not proved to be as effective as in the pre-pandemic period. At the same time, Estonian, Latvian, and Lithuanian democracies became vulnerable to anti-democratic threats to varying degrees. These observations that occurred when we were preparing final conclusions motivate the research questions about the nature of the reasons behind these differences. And my today's paper is motivated by this puzzle, and it aims to identify what anti-democratic measures were adopted to influence the sovereignty of the political nations, and which serve to either strengthen, maintain, or undermine that sovereignty. For the purposes of today's discussion, I have adopted Roman Becker's definition of a political nation, and it is defined as a set of equals who are part of one society and can decide on the most important matters of the state independently. And democratic states have these political nations that can make sovereign decisions. This domestic sovereignty is understood here as the ability to make final decisions. And the sovereign is the supreme ruler, so one who is no longer under anyone else's authority and everything depends on them. And let's move on towards some very basic methodological assumptions that underlined the introduction that I will deliver today. So to address the research questions I've already discussed, the study draws upon a method of source analysis, and the corpus of sources includes reports published on Verfassung blog, a blog giving voice to international experts, and it is a journalistic and academic forum of debate about topical events and developments in constitutional law and politics. And many of people that are present at our today's seminar provide great contributions to this blog, and they are worth reading, worth analyzing in order to understand the very nature of the contemporary changes in constitutional law and politics. And the corpus contains the reports that included the search phrases Estonia, Lithuania, and Latvia, as well as pandemic, epidemic, coronavirus, virus, and COVID-19, published from the pandemic outbreak of coronavirus disease in March 2002 to the mass vaccination in April 2021. Moreover, the qualitative report analysis served me to list Levensteinian anti-democratic measures, restrictions placed on democratic liberties of free speech, the press, association, assembly, universal suffrage, and organization in political parties, as well as to differentiate between those implemented to defend, preserve, or expand the sovereignty of a political nation, which is characteristic of neo-militant democracy, or challenge, undermine, and eliminate it, which, on the other hand, it is characteristic of quasi-militant democracy. And the analysis shows that although neo-militant democracy goals prevailed in the Baltic states' pre-pandemic political and legal structures, the pandemic-induced measures resulted in variation. In Estonia, the restrictions put the sovereignty of the political nation in jeopardy. At the same time, in Lithuania and Latvia, the sovereignty of the political nations was not under threat. So only in Estonia, the electoral successes and increasing support for the extreme political party, Conservative People's Party of Estonia, turned conducive to the movement from neo towards quasi-militant democracy. The government made attempts to meet the expectations of a radical part of the electorate. On the other hand, in Lithuania and Latvia, the extreme groupings did not receive comparable support and could not initiate an anti-democratic turn. What is also worth adding is that in Estonia, without consulting the parliament, the government declared a state of emergency. And that declaration drew on the definition of the epidemic as an emergency situation. And the Estonian government governed the state and addressed the pandemic by using executive orders based on the Emergency Act. And those orders of the government, as well as its crisis committee led by the Prime Minister, violated constitutionally guaranteed rights and freedoms, such as freedoms of movement and assembly. The researchers, the experts, provided arguments for the assumption that the repertoire of restrictions went beyond the Levensteinian set of measures. Furthermore, the government had supervision competence on the execution of the orders and compliance with the act. And although the Estonian government was not obliged to report to the parliament, its orders could be challenged in administrative courts if they transgressed, infringed constitutional freedoms or rights of a concrete persons. And here the practice showed that citizens raised complaints concerning, among other, surveillance issues, like in other European countries. Nevertheless, Estonia had no specific or accelerated procedures for challenging orders. That was also underlined by the experts. And therefore, administrative courts would process complaints after the state of emergency ends and in ordinary procedures. What is also worth emphasizing is the fact that in general, Estonians were deprived of adequate judicial control of the executive during the pandemic. Here, it is also worth underlining that the new legal and political structures created during the pandemic established opportunities to misuse anti-democratic measures and abuse power competencies. And as we saw, the government embraced this opportunity, mostly due to the lack of parliamentary control and discussion. The Estonian government could take advantage of new power competencies achieved under the state of emergency for its own benefit, and thereby challenge, undermine, and eliminate the sovereignty of the Estonian political nation. We can also add that when the Estonian case is concerned, the general package of emergency legislation contained new unrelated provisions and legislation that loosely refer to the pressing needs of crisis management. Instead, it fell into the government's political agenda, such as changing the present pension system and stricter controls on migration. So the government took advantage of the situation to perform their own political goals, to meet their own political interest. And when we look at the situation from the already described situation, we can point out that the political nation could not participate in that decision-making process, mostly due to the COVID-19 induced legal changes. However, in contrast to Estonia, Lithuania and Latvia did not introduce similar restrictions that would considerably limit the sovereignty of the political nation. Under Lithuanian constitutional law, health was considered one of the most significant values, and this rule established a legal legitimate objective for restricting several rights, such as the freedom of peaceful assembly. And those restrictions that occurred and were imposed under the quarantine resolution encompassed the ban of public events and public gatherings of more than 2 people who are not members of the family. Here, what is important to understand the condition of the sovereignty of the political nation in in Lithuania is the fact that the limitations did not exclude any part of the political nation from political decision making processes. So it was a distinctive feature of Lithuanians' neo-militant democracy creation. And in Lithuania, there were introduced there was introduced the right to appeal to court when human rights were breached. Additionally, members of the same as the courts, the president, the individuals could petition the constitutional court to conform to the government's acts with the constitution and laws. And unlike Estonians, Lithuanian citizens have timely access to justice during the pandemic. In Latvia, the government was authorized to impose some restrictions regarding, for instance, freedoms of public gathering and movement. And at the beginning of the pandemic, the government banned public gatherings over 200 people. However, at the end of March, the ban was extended to all such events, including religious and private gatherings, except for funerals outdoors, respecting 2 meters distance rules. Later on, baptism ceremonies in urgent cases were considered another exception. However, like in Lithuania, the restrictions did not exclude any part of the Latvian political nation from political decision-making process. Furthermore, Latvians also had timely access to justice, once again, in contrast to Estonians. This brief comparison of the Baltic states uncovered that in Estonia, the anti-democratic measures were adopted to undermine the sovereignty of the political nation. The government abused the extended power competencies to perform its own political agenda. The situation was completely different in Lithuania and Latvia, where anti-democratic measures were not used to undermine the sovereignty of the political nation. So they were not misused, and they served rather to maintain the sovereignty of the political nations. So accordingly, in those two neo-militant democracies, the restrictions worked as precautions intended to prevent the spread of coronavirus and protect human lives, and have not to strengthen the ruling parties, or to meet their own goals to strengthen their political agenda. To sum up, the analysis exposes the role of social consent to implement anti-democratic solutions. In Lithuania and Latvia, unconditional opposition to the inclusion of anti-democratic forces in the government erected a pretty strong barrier to abuses, even during the crisis that encouraged malpractices. In contrast, as we could see in Estonia, crisis management became a tool in the hands of democratic forces to extending their power competencies. And this case uncovers the fact that the lack of adequate procedures to resolve a crisis, along with the social support for anti-democratic forces and their electoral success, may trigger a movement from neo to quasi-militant democracy. And on the basis of the analysis, we can formulate a set of recommendations related to the very process of creation, crisis management programs and plans that would not considerably undermine the sovereignty of the political nation. And some of them include the fact that the laws regulating emergency situations should be revised to avoid future infringements of the principle of the rule of law. Supervisory mechanisms should be developed and amended so as to provide citizens with the responsibility to control the protection of their own rights and freedoms on an ongoing basis. And as we could see, since the state of emergency generates a field for power competencies, means the laws have to guarantee the constitutional rights and freedoms will not be breached arbitrarily by unconstitutional order and restrictions that have no basis in the law. And usually those has to reactive and haphazard changes during the implementation of crisis management rules are not recommended. Instead, in the early post-pandemic world, the state legislators have to face the challenge of reviewing the existing crisis management procedures and laws. It is worth to make them research-based. And the pandemic-derived experience in regulating political, legal, and social structure should be widely discussed and consulted with civil society, because a social constant to the implementation of anti-democratic measures proved to be meaningful. And finally, the existing and constantly developed regulations should be controlled not only in terms of compliance with the applicable law, level of effectiveness in combating the threat, the level of social acceptance, but also the influence on the sovereignty of political nations. Thank you so much for your time. It was a great honor to deliver a speech today.
Thank you very much. Can I ask Monique about short question or comment and short answer for Jan?
Yeah. Actually, I'd like to make a short suggestion, not a question. I guess it would be really amazing because the title of your paper, Social Constants to Implement Anti-Democratic Solutions, it's really, really amazing. I mean, because we have a lot of contradictions that we can think only with your title. So I would suggest after, not now because I guess we don't have so much time, but we could discuss a little more, for instance, Agamben theory about the civil disobedience. Maybe it can be quite interesting to discuss this one, just like in dialogue with Max Stoya paper. I guess it would be great to have this kind of discussion. I mean, yes, that's the point, because you have great empirical cases between the relationship of government and the civil society, of branches of civil society. So I guess it would be great to make a dialogue between them. That's actually a kind of a suggestion only. Thank you very much, Roman.
Thank you very much.
Thank you so much for this suggestion. It is very interesting to include this category to studies on neo-militant democracies. Nobody has done it, so it is a challenge to be faced. Thank you so much.
Thank you very much. Can I ask, last but not least, for very short, max 15 minutes, Maciej Skrzypek from the same university, Adam Mickiewicz, Smart Quarantine versus Strict Lockdown, Restrictions of Political Rights in Czech Anti-Pandemic Strategies. Can I convey, please?
Good morning, everybody. First, I would like to thank you for the opportunity to present my results of my research, and I'm aware that the last speech in the panels should be a proper dynamic, so I do my best to limit in 15 minutes. I prepare some presentation, so wait a minute for sharing with you my screen, and let's start. It's a great honor to be a part of our symposium and the possibility to share my results about sharing the results of my research about the changes in anti-pandemic policy in Czechia during the first year of pandemic. The main conclusion of my research is following that transformation anti-pandemic policy in Czechia during the first year of pandemic had a significant impact on protection, political rights and freedom, and violation them, despite the similar level of measures restrictions stringency during the first wave of pandemic and the second wave of pandemic. Firstly, I think that it's more important to say something about the technocratic approach to governing a state as a company by former Prime Minister Andrej Babis, who at Strategic Forum in Bled at August 2020 convinced that Czechia, thanks his technocratic approach to governing state, has the best results in dealing with the coronavirus crisis. However, a few months later, he apologized for a dramatic situation in Czechia, especially one of the highest index of death on coronavirus in Europe, and asked for further legitimization of his government policy. On Diaz diagram, you can see my proposition of division first year of pandemic in Czechia, and the turning point is the outbreak of second wave of pandemic in October 2020, when the government decided to redeclaring a state of emergency and adopt strict measures again. The first signals of changes anti-pandemic strategy in Czechia we saw in summer 2020 when Prime Minister Babis nominated a new Minister of Health and changed his approach to expert recommendation and opinion and ignoring it in practice. And the observation from this diagram and based on the stringency index proposed by Our World in Data is following that similar level of restrictions of measure stringency during the first and the second state of emergency is similar. So the different impact on political rights should be found in other reasons. And in my presentation, this is my aim to find other reasons of these significant changes in protection political rights and freedoms. Moving to first wave of pandemic, and which is start in March 2020, it is worth to say that first restrictions and anti-pandemic measures were adopted in February before confirming first cases of coronavirus in Czechia. The banning flight to and from China and other countries recognized as higher risk was implemented in February, and the restriction on political rights and freedoms were implemented after declaring a state of emergency 11 days after confirming 3 cases of coronavirus. The state of emergency was declared by government, and opposition and whole parliament approved it, and one of the first decisions was postponing a supplementary election to Senate. The authority state didn't organize it with the strict sanitary regime and measures to reduce social contacts, which directly limiting a right to vote and to be voted, and obviously interfered in constitutional procedure of election. However, this decision was still legal based on the emergency provisions. The other restrictions were adopted step by step, including the banning of public gatherings, what limited the freedom of assembly. It is worth to say something about the stringency index, which was very high during the state of emergency to May 2020, and the medium after cancelling it, what should be recognized as proper reaction on stabilization pandemic situation in Czechia. In my opinion, for detailed discussion about the limitation and the reducing rights of and freedoms should be based on 3 poles of limitation. The first of them is the schedule of parliament work. Since March 2020, numbers of deputy sessions were reduced, like other countries in Europe, but it should be recognized as declining opportunities to undermine government decision and present opposition statements. However, the government, like in Hungary and other countries in our region, start governed by resolution, by decrets based on emergency provisions Of course, in undermining anti-pandemic restrictions, the significant role opposition play a significant role, and municipal courts in Czechia. In April 2020, parliamentary opposition in Czechia informed about preparing a complaint to Constitutional Court on closing supermarkets and banning free movement. But finally, opposition withdrew it, and government decided to canceling these measures a few weeks later. In April 2020, municipal court in Prague recognized that above-mentioned restriction on banning free movement and closing supermarkets was unconstitutional. However, the government, the Babiš ignored that judgment. And the third, full of limitation political rights and freedom, in my opinion, during the first wave of pandemic, it is the blocking access to public information and the media relation, with independent outlets after leaks about involving Agrofert company very close linked with Andrej Babiš in delivering respirators and other medical equipment. Ruling elites decide to blocking access to some media outlets, the access of public information, of course, which inform about the mistakes and abusing power during the coronavirus crisis. It is obviously that this decision limits the freedom of assembly and independence of non-government-friendly media outlets. In the face of spreading fake news about the coronavirus, the blocking access to public information had a negative impact on dealing with the pandemic, and the government didn't prepare any information campaign about the coronavirus, and didn't cooperate with independent media to improve citizens' knowledge about the COVID-19. To sum up the first part of my presentation, I would like to say something about the smart quarantine, which is called the first strategy which I analyzed. The smart quarantine based on adopting measures to reduce the very fast and strict measure to reduce social contacts and close cooperation with the government, with the epidemiologist in setting anti-pandemic agenda, and close cooperation with the ICT experts to detect coronavirus symptoms. Smart quarantine had a very positive remarks formulated by experts and international observers. However, some Czechia epidemiologists and experts on public health formulate another recommendation in dealing with pandemic in the future. One of them is that the statement that local lockdowns are more effective than national lockdowns and banning free movement. And moving to the second wave of pandemic, after several months of pandemic stabilization in Czechia, in October 2020, when the numbers of new cases dramatically increasing, a government decided declaring a state of emergency and adopted restrictions. Again, the state of emergency in constitutional provision was prolonged until February 2021, when opposition in parliament rejecting a government application for prolonging it. This decision based on the dramatic pandemic situation and getting worse and worse economic condition of domestic entrepreneurs. The social trust and support for government declined, what was the result of dramatic pandemic situation. Czechia had one of the highest death index in Europe, and beliefs on restrictions effectiveness declined week by week. After rejecting application for redeclaring of prolonging a state of emergency, government decided to approve a new law which giving the Minister of Health extraordinary power to, in practice, impose lockdown, especially the economic restrictions, without an obligation of forcing emergency provision. And based on it, the government in practice adopted a new kind of unconstitutional state of emergency with the similar level of restrictions based on the data shown by our World in Data. And finally, I would like to formulate some conclusion about my research. The declining level of protection, political rights and freedoms was effect of changes in legal basis of restriction and adoption that unconstitutional type of state of emergency in February 2021, based on second on the duration of the forcing restrictions, the reducing pulse of undermining government decision, and finally, the role of expert and epidemiologists in setting anti-pandemic policy. Thank you so much.
Thank you very much, Martin. Can I kindly ask Monica for a last question, last comment,
Yes,
please?
thank you very much. Messier, that's really amazing, your work. So it makes me think about the relationship between individual rights and individual liberties from one side, and the other side, the collective public health, which is quite important also. So I would like to ask if you can make a if you can see this other side also. How do you see? Because I could see that you, as far as I could see, your work was a kind of a critic on the smart quarantine. So I'd like to hear if you have some ideas about the other side. Yeah, and and I thought about maybe that's an author that can help us also, maybe Ulrike Beck with Society of Risk or Risk Society. I don't know exactly the name of the book in English, which is quite interesting also because he shows us that we are facing threats that are not so concrete in the environment and the globalization world and field. So I don't know, maybe if it can also be a kind of an input for your work. So that's it. Thank you very much.
Yes, please.
Thank you so much. In referring to the smart quarantine, I think based on the recommendation, the remarks about the specialist about the public health, in that time, in that context of implementing some restrictions, it is a positive reaction on the coronavirus crisis, and the social reception was very high in that moment. So I think if during the second wave of pandemic, the government in Czechia implemented the recommendation of experts, should be continuing a smart quarantine, because it's not about the restriction of political rights, but the close cooperation with experts on new technologies, about the close cooperation with epidemiologists. But former Prime Minister Babis ignored them and stay with his technocratic approach.
Thank you very much. I didn't see any hands up, and I suppose there are no other questions or comments. I would like, from the reason, to say many thanks for all panelists for so excellent papers, and especially my thanks for Monique for wonderful, very deep intellectual comments and questions. And I suppose Professor Skrzypczak has especially new for all of panelists, for all of us. Please.
Yes, thank you very much. I completely agree with you. Thank you, all speakers, for very interesting speeches, presentations. Thank you, Monique, for your great work and very fruitful comments. And finally, thank you to chair, to Roman, for excellent work and a very good sense of timing. Thank you very much. And maybe tomorrow we will have some announcement about the publication. However, we consider with Oscar Perez La Fuente to publish some of presentations, papers, maybe all. We will see. However, we have such idea. However, maybe tomorrow we will present more details about this. Okay. So once again, thank you very much. And we will see soon, because 2:30 we will start next 2 sessions, in fact, in Polish language, and of course here on this channel, English. Panel, the right to health and healthcare and equitable access to vaccination during COVID-19 pandemic. So I hope we will see soon. Now, I'm sorry, this is a private coffee break or lunch break. I'm sorry, because in normal time, I think that we should have some proposal for all of you. However, soon, I hope soon, it will be possible.
Thank you very much.
Thank you very much. Thank you very much. See you.
Thank you so much.
Thank you, Asia.
Thank you.
Thank you, Mikołaj.
Thank you very much. Bye.
Thank you.
Bye. Thank you very much.
Bye-bye. Roman, thank you for your wonderful voice and your wonderful speaking. I love it, really. Thank you very much. Really amazing.
I trained
I hope to hear
especially
more you speaking. It's really amazing.
I trained especially to hear for you. Thank you very much.
So,
bye bye.
Excellent
It was a
cooperation.
pleasure
Thank you very much.
Be with you all. Bye bye.